at the speed of 140 words per minute from Shekhar Shorthand magazine, a Supreme Court judgment. 1, 2, 3, start. One of the members of the earlier bench, Honorable Mr. Justice Korean Joseph, was due to demit office on 29 November 2018. The miscellaneous application was instituted on 22nd November 2018. On 28 November 2018, a bench consisting of Honorable Mr. Justice Korean Joseph and one of us, Honorable Mr. Justice Hemant Gupta, issued notice on the miscellaneous application. 22nd. We accordingly clarify the earlier order dated 12 December 2017 by directing that it would be open to the appellant if we aggrieved by the order that we may be passed by the High Court in review to challenge both the order in review and original orders in the writ petitions. However, this liberty is confined to the issue for the catch-up rule. In issuing this clarification, we have also been guided by an earlier precedent of a two-judge bench of this court in the Maharashtra Chamber of Housing Industry versus Municipal Corporation of Greater Mumbai. A bench of this court consisting of Honorable Mr. Justice S. A. Bobde and Honorable Mr. Justice Ashok Bhushan passed an order on 16th August 2016 in the following terms. In the circumstances, we permit the petitioner to approach the High Court with a review petition along with the appropriate application for impleadment. The High Court shall decide the issues raised by the petitioner afresh as expeditiously as possible. The special leave petitions were accordingly disposed of. Subsequently, on 5th December 2017, while considering an application for modification recall of the earlier order, a two-judge bench consisting of Honorable Mr. Justice S. A. Bobde and Honorable Mr. Justice L. Nageshwara Rao observed, thus having regard to the circumstances of the case and the importance of the matter which affects the construction activities in the entire city of Mumbai, we consider it appropriate to modify our earlier order dated 16th August 2016 passed in SLP Civil number 24660-24661 of 2016 by expressly granting liberty to the petitioner to challenge the impugned PIL order as well as the impugned review order before this court. We order accordingly. Hence, the aforesaid applications for modifications recall are disposed of in the above terms. Learned Senior Counsel appearing on behalf of the first respondent relied on a judgment of this court in Susil Finance and Leasing Company versus M. Lata, where it was held thus. These special leave petitions are against an order dated 12th December 2003 passed in review petitions. It must be mentioned that against the main judgment, special leave petitions had earlier been filed. However, when those special leave petitions reached hearing on 1st September 2003, the following order came to be passed. After arguing for some time, the learned counsel for the petitioners seeks permission to withdraw the special leave petitions to seek review of the order of the National Commission. Permission is granted. Accordingly, the special leave petitions are dismissed as withdrawn. It is clear from the order that the matter was argued for some time. It is clear that the court was against the petitioners. Thus, as has become common nowadays, counsel applied for withdrawal on the ground that a review will be applied for. Thereafter, the review applications were filed before the High Court, which have now been dismissed by these special leave petitions. The order dismissing the review petitions has been challenged. In the case of Shankar Motiram Nale versus Siolashing Gansing Rajput 1994 2 SEC 753, it has been held by this court that against an order rejecting an application for review, a special leave petition is not maintainable. This authority is directly on the point in issue. In the above case, it is evident that the petitioners had sought permission to withdraw the special leave petition after arguing the matter for some time to seek a review of the order which was impugned. Granting permission, the special leave petition was dismissed as withdrawn. It is clear, therefore, that there was nothing to indicate that the court had granted permission to move this court afresh against the original order after the review was decided. In Abhishek Malviya versus Additional Welfare Commissioner, a special leave petition was filed before this court against an order of the Additional Welfare Commissioner in a matter involving a claim for compensation arising out of the Bhopal gas leak disaster. One of the grounds of challenge was that the Additional Welfare Commission had referred to the appellant as deceased. This court dismissed the special leave petition as withdrawn, recording the submission of the appellant that he wishes to move the Additional Welfare Commissioner for correction of the order. After the Additional Welfare Commissioner passed a fresh order, writ proceedings were initiated before the High Court. The High Court held that by the earlier order of this court, liberty was reserved only to move the Additional Welfare Commissioner to correct a typographical error in appeal. This court affirmed the order of the High Court 2008 3 SSC 108, holding that its earlier order had merely reserved liberty to move the Additional Welfare Commissioner for correction of a typographical error. In Vinod Kapoor versus State of Goa, a special leave petition before this court was dismissed as withdrawn, recording that the petitioner had filed a review petition in the High Court. No liberty was taken to file a fresh special leave petition against the order of the High Court. In that context, this court held this: as the appellant has withdrawn the special leave to appeal against the order dated 29 January 2000, Vinod Kapoor versus State of Goa of the High Court, with permission to pursue his remedy by way of review instead, and had not taken the liberty from this court to challenge the order dated 29 January 2000 afresh by way of special leave. In case he did not get relief in the review application, he is precluded from challenging the order dated 29 January 2000 of the High Court by way of special leave to appeal under Article 136 of the Constitution. The same view was reiterated by another bench of 2 judges of this court in Sandhya Education Society versus Union of India Sandhya Education Society, where this court had permitted the withdrawal of a special leave petition with liberty to institute a review petition before the High Court. No liberty was granted to file a fresh special leave petition thereafter. This court held that once a special leave petition is dismissed as withdrawn without obtaining appropriate permission to file a fresh special leave petition after exhausting the remedy of a review petition before the High Court, it would not be maintainable. Stop.